District and subordinate courts, under the Civil Courts Ordinance 1962 and criminal courts created under the Code of Criminal Procedure 1898, the subordinate judiciary may be broadly divided into two classes: 1. Civil courts, and 2. Criminal courts. In addition, there also exist other courts and tribunals of civil and criminal nature created under special laws. Their jurisdiction, powers, and functions are specified in the statutes creating them. The decisions and judgments of such special courts are assailable before the superior judiciary, high court and/or Supreme Court through revision or appeal. The provincial governments fund the justice sector. The civil courts and criminal courts judges and their terms and conditions are regulated under the provincial rules. The High Court, however, exercises administrative control over such courts. The civil courts consist of district judge, additional district judge, senior civil judge, and civil judge class 1, 2, and 3. Similarly, the criminal courts comprise of sessions judge, additional sessions judge, and judicial magistrate class 1, 2, and 3. Law fixes their pecuniary and territorial jurisdictions. Appeal against the decision of civil courts lies to the district judge and to the High Court if the value of the suit exceeds a specified amount. Similarly, in keeping with the quantum of penalty, appeals against criminal courts lie to Sessions Judge or High Court. The Code of Criminal Procedure, 1898, prescribes the criminal procedure. The Kanuni Shahadat Order, 1984, prescribes the competency of witnesses, the examination of witnesses, form of evidence, and the procedure for presenting the same. The procedure prescribed in the law applies to judicial proceedings and investigations by a court in civil or criminal cases. The special courts follow the procedure prescribed in the above-mentioned codes, whereas some such courts follow special procedure laid down in the respective statute. People are losing confidence in the judiciary system because the legal fraternity is not observing ethical values in legal practice. A newcomer used to join some chamber not only to learn how to practice law, but also to learn mannerism, the way he should be dealing with the court and clients. This is not in practice anymore, as the system is eroding. Justice Amr Faroug, senior judge of the Islamabad High Court. Model courts, Article 37(d) of the Constitution requires the state to provide expeditious and inexpensive justice. Thus, under the light of this principle, model trial courts have been established in the country to carry out trials daily. Model courts are special courts within the existing judicial infrastructure. The working of the model courts. A trial schedule will be provided to lawyers and prosecutors so that they can follow it to a T. In case the lawyers are unable to appear before the court on the day of the case, they will have to let the model trial court know who will replace them so that the trial is concluded within the stipulated time frame. To ensure the timely conclusion of cases, model trial courts will not grant any adjournments. The attendance of witnesses would be ensured through process servers, for which SP investigation of each district will act as a focal person, liaising with the process servers. A process server is a person who serves legal documents, summons, to someone involved in a court case. SP investigation will also be responsible for the production of all witnesses, except medical witnesses, and case property, evidence. Former Chief Justice of Pakistan, Asif Saeed Khosa, said that for the timely production of medical witnesses, those who have serious health complications and cannot appear before the courts, the secretaries of the relevant health departments would be approached. A monitoring and evaluation cell under the supervision of CJP, or Chairman NJPMC, National Judicial Policy Making Committee, will oversee the workings of the model trial courts. The performance of these courts would be reviewed every 2 months, the Chief Justice said. Initially, pending murder and narcotics cases were assigned to these courts. Performance of the model courts. The 465 model courts, which have been set up across the country to provide speedy justice and to clear the massive backlog of cases, decided 50,743 cases, including 7,356 cases of murder and 12,168 of narcotics during April to October 2019. Witnesses of 124,669 were recorded during the hearing of various cases, while 182 model criminal courts also disposed of 13,571 criminal cases along with murder and narcotics cases. The statistics show that the model courts in all the four provinces and the Islamabad Capital Territory have given good results by deciding cases in a few months, which might otherwise have dragged on for years. The former Chief Justice of Pakistan, Asif Said Khosa, said that indeed model courts materialize the vision of expeditious and inexpensive justice as envisaged in Article 37D of the Constitution of 1973 of the Islamic Republic of Pakistan, which otherwise was just a dream before the establishment of model criminal trial courts in the country. Efforts, devotion, and commitment on the part of model court judges turned the dream of speedy and inexpensive justice into reality, and litigants are getting prompt relief. The credit goes to the model court judges who rejuvenated the ailing judicial system under existing and available resources and without any amendments in the given law. It has instilled a new spirit into the masses to repose confidence in the institution of the judiciary, which otherwise had always been blamed for undue delays. In most developing countries, court cases linger on for years and decades. There are several causes of this. Law courts have to be fully satisfied before they deliver their judgments. The basic principle on which law functions is let 99 murderers go scot-free, but no innocent should be punished. Law courts are not supposed to rush through while deciding cases. However, sometimes some circumstances arise when speedy trial courts are set up to clear the logjam of cases. Adjournments sought by lawyers also delay cases. In recent years in Pakistan, lawyers often go on strike to protest issues confronting society as a whole and sometimes only themselves. Unnecessary delays in the dispensation of justice should be discouraged. This is what the model courts are doing.